Not to mention our guy Mike Satawa of Satawa Law. Mark Satawa, I apologize.
Mark Satawa, yeah. What?
I said Mark the first time. It's hot, dude.
It's
hot. Our air conditioning's broke.
It's the heat.
How you doing?
Hey, gentlemen, how are you?
Good. How are you?
How are you? It's excellent. It's a pleasure to be on the heavyweights.
Thanks for joining us. And first thing, we need your initial reaction of what Harvey Steinberg did in that courtroom to help, because it seemed like before that happened, everybody was saying, oh, he's facing 8 felony cases, he's done, he's gone, he's going to go to jail. And then Harvey Steinberg comes in there and just absolutely puts on a clinic.
Yeah, well, look, Harvey's very well known, represented a lot of professional athletes, and he certainly knows what he's doing. What happened though is not all that unusual in criminal cases, in the sense that, Terrion got arraigned, what was it, Thursday or Friday, and the Florida system for setting bond is very similar to the federal system, where you get arrested initially, and each side has the ability to ask for days to get ready for a detention hearing. Terrion's lawyers asked for a pretty quick one. It was held Monday morning, and it's not uncommon for people to be detained pending that hearing for a couple of days, which is what happened with Terrion. Then you have the detention hearing. The burden of proof is on the prosecutor. The prosecutor has to establish the two main issues are always flight risk. Are you a flight risk? Are you going to show up in court? And are you a danger to the community? The danger to the community one is the one that I think the prosecutor tried to hammer on in the courtroom. All kinds of reporting and quotes from the prosecutor talking about the as you guys said, the 8 felony capital counts, all carrying up to life in prison, and to your point, I mean, Harvey did a very, very good job of saying, look, this is a guy who he's very well known. He can't hide anywhere. There's no way he's going to hide in plain sight, right? I mean, I think the judge even made a quote about, like, look, if you're even late to practice, we'll hear about it at ESPN. So, I mean, Harvey did a really good job of saying, hey, look, this guy is so high profile. He's not a flight risk. He's not a danger to the community. And I thought the judge's quotes were pretty telling. I mean, Terrion is the only defendant in this case that's not detained pending trial. He's the only one out on bond. The judge's quotes in issuing the order was, look, the prosecutor has established probable cause, but in terms of enough evidence to detain him to convince me that he's a danger to the community, I think the judge's exact quote was, we're not there. We're not there yet, at least. And so it should be a very, very interesting case moving forward. But look, Terrion has the old saying about he's got the best defense money can buy. He's got some excellent attorneys for sure.
I agree. I thought Harvey was. I compared to watching LeBron in his prime, the way he was cooking in the courtroom there. I guess the question I had too is, like, I mean, essentially he had the judge questioning the law through the prosecutor. He's like, no, what's illegal about this? Is that like, if you're a lawyer, is that like gold for you to hear? Like, you're like cha-ching, because all you gotta do is convince one of the jurors, right?
Yeah, you're starting with the point. Terrion is not charged as what's called a principal. You've heard that term kicked around a couple of times during the detention hearing on Monday. He's what's called an aider and abetter, or an accomplice. He's charged under principal theory, which allows prosecutors to basically say, if you were involved, you could be charged with the same crime, the same penalties as the person who committed the offense. But easy, you're right. I mean, the judge flat out said, like, asks the prosecutor, is it illegal to confront someone about your phone being missing? Is it illegal to invite someone over to confront someone? But I need more. You got to show me that he actually did something. And so in most cases, when you are charged under an aider and abettor theory, they have to prove you knew the crime was going to be committed. You have to share in the intent. You have to want to help the accomplishment of that crime. And so that is sometimes kind of a difficult thing for prosecutors to do. As you're saying, Easy, I mean, jurors kind of like to sort of have things sort of make sense to them. 1 + 1 should equal 2, A, B, C, D, E. They don't like kind of like disjointed, disconnected facts. And yeah, Terrion Arnold has fingerprints, to use a analogy, seem to be kind of all over this case. But is there really evidence? Where's the proof he actually participated, even as an aider and abettor, in the commission of this offense? It sure looked like round one went to the defense for sure. Easy. When the judge is questioning the prosecutor, yeah, hell yeah, you're sitting here going like, yeah, I like where we're at.
Hell yeah.
They said that really the only stuff they have connecting Terrion Arnold to the actual crimes is the testimonies of the two co-defendants that have flipped. And they are obviously, being charged with similar crimes. How easy or difficult would it be to kind of break down those defendants and to prove like they can't be, credible witnesses?
So that look, you guys are zeroing in on the critical part of the case. Anytime there is accomplice snitch testimony, it becomes very, very difficult to on its own without corroborating evidence. Again, jurors have a very, very understandable and visceral reaction to accomplice testimony, to snitch testimony. You have convicted felons who are facing life in prison, who are getting a deal in order to testify against the one guy. I think that Harvey even called him the trophy defendant in the case, the one guy that everybody knows. And so I think there's going to be skepticism. Any juror looking at this case is going to start from the starting point of this guy's testimony is being paid. And if you were a juror and you hear that testimony is being paid, your natural reaction is going to be, well, how much how much can I rely on this? Well, they're being paid in something far more valuable than even money, right? They're being paid with years of time off of their sentence. Their sentences may be getting cut in as much as half or even more. So as a starting point, as a juror, you look at that and you say, all right, you know, I feel some BS here. I gotta be convinced that there is credible, reliable reasons to buy this testimony. Now, the flip side of that is where the prosecutor has to sort of buttress or help that out, or is one of two ways. The first way is to point out the obvious that, okay, these guys may be convicted felons, but they're Tyrion's friends, right? That Tyrion does have a relationship with them. And when I was a prosecutor, I always used to argue to juries like crimes committed in hell don't have angels as witnesses. So, look, if you're going to have somebody talk about putting a plan together to rob some people and confront them, beat the hell out of them to get somebody's property back, you're going to have some scumbags that are the co-defendants, and they're the ones that are going to be the witnesses if there's going to be. So you really got to kind of hammer that. But more important than that, and we're going to go back to something you guys referenced earlier a few minutes ago, and that's what the judge was asking the prosecution and also the defense during the hearing. I think an excellent job. Again, when your arguments are picked up by the judge, you know you're hitting home. But the defense attorney's argument and the judge repeating them was, look, there's nothing on social media. There's no physical evidence. The only thing we have, there was no texting. This idea that there were text messages is just completely wrong. It's not there. So what prosecutors usually want to see, what they usually want on, and if they don't have it here, I agree with you guys that I think it's going to be a little bit of an uphill battle. But what they're looking for is cooperation. You want to take this snitch testimony that is going to be liable, that is going to be looked at skeptically by a jury, and you're gonna want to corroborate it. You're gonna want to buttress it, right? Like, look, they said Terrion told them to go do this, and here's a text message. They said Terrion was outside the apartment, and here is his GPS data that shows he was right in the parking lot. They say Terrion was FaceTimed, and look, here's his FaceTime, here's his cell phone bill, and there's a FaceTime from that number to Terrion at the exact right time. If they're not able to come up with that kind of corroborating evidence, that kind of that evidence that gives what the snitches are saying, these cooperators, some collaboration, some reliability, that is going to be a tough sell. That will be a tough sell to a jury. To rely just on snitch testimony is a difficult road to plow.
We appreciate your time. We got some connection issues. I think we're gonna let you get going, Mark. But anything you want to say before we let you get going?
Hey guys, it was a pleasure.
Hey,
No, thank you so
appreciate
much.
you and your time. I wish I was where you were at right now.
Yeah, you're the expert here.
Are you on a boat right now?
Take maybe.
Shout out to Papa
out.
Sats. We appreciate you tapping in, and it's Woodward Sports' insider to everything in the courtroom.
Satawa Law.
Satawa Law.